I'm Scott Lachlan. This is the Data Chronicles, and here are your data points. Today, we are discussing the FTC's new click to cancel rule. The new rule is intended to make it easier for consumers to cancel recurring subscriptions and memberships, of which I think we all increasingly have many. And while its intent seems pretty straightforward, its impact, I think, will be broad and require changes to business practices and consumer terms, user interfaces, and backend controls. And it also takes effect in an important context where heavy focus remains on the intersection between the user experience, user choice, data, and consumer protection. It's also a rule that underscores an important point for folks in our profession. Data protection professionals are really at the front lines of all things data, whether they are privacy, cyber, data protection, or technology. This is a rule, while it's not strictly a privacy or cyber oriented regulation. It will indeed have impact on e-commerce and data subject rights and compliance programs. And the expertise in this role will likely fall squarely within the tool set needed for those guiding their organizations and clients on all things data. So let's jump right into it. I'm very excited to discuss the role with my colleague, Harsimar Danoa. Harsimar is a frequent guest on the podcast, especially because one of his specialties is actually tracking and advising on these emerging regulations and state law developments. Harsimar, welcome back to the podcast.
Thanks, Scott. Glad to be back on.
So maybe, Harsimar, why don't we start at a high level? What is the click to cancel rule, and why is it being enacted at this moment?
So the click to cancel rule is a new trade regulation that the FTC, the Federal Trade Commission, has issued under their Section 5 authority. And one of the interesting things is that, so Section 5 is the general consumer protection statute against unfair and deceptive acts or practices. It's pretty wide reaching. And the FTC has also had separate authority under a statute called ROSCA, the Restore Online Shoppers Confidence Act. And ROSCA in particular has focused on negative options, essentially features where if you don't take any affirmative action, your subscription is going to renew or you'll be charged for another iteration of the product, typically what we think of as auto renew itself. And so for the longest time, the FTC has focused on these negative option features solely in the context of ROSCA. And now they've actually taken an additional step of saying, you know what, we have rulemaking authority under Section 5. We think that these practices are rampant in the industry. And so we are now actually going to issue a regulation saying that in addition to ROSCA, here are related practices that are going to be unfair and deceptive practices.
So maybe, Harsimar, can you maybe describe a little bit more about what a negative option looks like, and why is it that the FTC is focusing on this? Because I think these, obviously there are many new subscriptions. We probably have many of those subscriptions in our personal lives, and we increasingly see advertisements and where financial organizations, banks, the credit card companies are saying, hey, we're going to give you a list of all of the recurring subscriptions that you may not even remember that at one point you signed up for. And it sounds like one of the key aspects here is that even if you remember that you do subscribe to a subscription, that there could be pain points for consumers to be able to have those canceled or terminated.
Yeah, Scott. So this is one area where both the FTC and Congress had heard a lot of complaints from individuals around, maybe they bought a specific product and they thought they were just getting one item and they ended up actually being charged as part of a broader subscription. So a month later or 6 months later, they look at their credit card statement and all of a sudden there's a charge they didn't expect. And so the focus around these negative options was really on making sure that there was clarity for consumers on, you may be buying something now, but what is the actual process for recurring transactions? What is the process to cancel those if you're no longer interested? And so that has been, through ROSCA, a big focus of the agency. They've also started looking at it in the context of dark patterns, which I know we're going to talk about later on in the podcast. And so this has been a big focus around user architecture. How easy is it for someone to sign up? Is it as easy for them to cancel the subscription? And so it's started to come to a head, particularly as complaints have started to escalate, and the FTC sort of felt that it needs to take action.
Yeah, I mean, because there's not really any existing requirement that a termination of a subscription is in any way standardized. In other words, as you are signing up for service one, while oftentimes the way that you sign up for that looks very similar to how you have signed up for other subscriptions, the way that you terminate those subscriptions looks very different. And so is this going to mean that there's a giant red button that has to be included on a website that you say, end my subscription, and then there's some consequence to that? Or does this look different or still allow for more of a custom approach to organizations to have their subscriptions canceled?
So there is flexibility. It's not like you have to have one common red button that says cancel my subscription. But both under ROSCA and under this new trade regulation, the click to cancel rule, there's a focus on providing a simple mechanism to cancel the negative option feature in particular. And so one thing that you will have to think about is, okay, well, how many clicks does it take for a person to sign up? What does that process look like? And then compare that sign up flow with what does the process look like to actually cancel a subscription? I think the common complaint that has come up, one of the stereotypes is around gyms, where gyms make it very easy to sign up. You can go in person, and they're happy to get you, signed away with a contract. But oftentimes there is a more difficult process around, well, you need to send a written letter within a certain time period to a certain office. And after X amount of time, then your gym membership will be canceled. And so essentially with situations like that, the FTC is saying, listen, that is not a simple mechanism. And so there is flexibility on what simple means, but it'll likely be taken in comparison to how easy is it to sign up, and is it as easy to sort of cancel the subscription too?
I mean, I'm reminded, right, of the gym analogy is that if you're old like me, Harsimar, you'll immediately remember sitcom episodes where they were devoted on this. I think there was one in Seinfeld and one in Friends, specifically where you had a recurring gym membership that was never used, and that the characters had a lot of difficulty figuring out how to cancel and ultimately had to try to go back to the bank to cut off the funds to begin with so that they were no longer charged. But I mean, in a more serious way, is this mean if it's, quote, simple, that gives then back the discretion to e-commerce platforms to come up with what they think is simple, no giant red button, but something that may look like a very clear way for organizations to allow their customers to cancel, but still no regimented way of doing that? It sounds like discretion remains with the platform itself.
That's right, Scott. And candidly, it's a little bit of a two-edged sword in that, on one hand, it does give businesses more flexibility so that they can align their cancellation process with, the rest of their business operations or the look and feel or existing processes they have in place. On the other hand, it also gives the agency more flexibility to say, listen, we know you've taken certain steps, but we don't think that this method is actually simple, whereas in comparison, if it was one red button, that's slightly easier to comply with because this is what the agency is expecting. This is what I need to do. And I can just sort of, I may have to take my licks and when I put it in there because it's not going to be the way that works with the rest of my systems. But after I've implemented it, I know that I've met the requirement pretty cleanly.
Right. So it sounds like this is on brand for maybe past FTC actions where, they will maybe over time kind of establish maybe a more specific set of expectations about what constitutes a simple mechanism for individuals to terminate their relationships. All right, so we have a very specific set of actions that are contemplated here. Maybe just taking a step back, Harsimar, I want to kind of think about this in light of the many other areas where user interfaces are being examined from a regulatory perspective. Because in many ways, what's driving this rule seems to be the same kind of set of concerns that are driving regulation or scrutiny around dark patterns. Interested if you see it that same way and where you feel like this particular focus will go.
Yeah, so there are actually a few, dots that are really clear to connect here and how they all sort of play together. So if you look at past enforcement actions from the FTC, they actually have used the word dark patterns. And interestingly, they haven't used it as often in the deception claims or unfairness claims, they typically use them when they're enforcing ROSCA as sort of the primary mechanism. So they're using them in the context of these negative option features. Now, that said, we have, in a separate lane, states that are passing consumer privacy laws that say, okay, here are standards for consent, but if you use dark patterns when you're getting consent, that will no longer be considered valid. And so you're starting to see an initial connection. I'll even add some states go an additional step of saying, we consider a dark pattern to be anything that the FTC identifies as a dark pattern. So strengthening that connection together. But you're exactly right. There is a greater focus now on user choice architecture, making sure that in the same way of talking about how easy is it for someone to sign up for a subscription and how easy is it for them to cancel this negative option, a similar focus from privacy regulators around, well, if we're going to have consent be a requirement, how easy is it for a person to give consent? And then how easy is it for them to withdraw consent? And wanting to see some parity there as well. So even though the FTC is focused on negative options previously, the implications are pretty clear that regulators are going to be looking at this and trying to extract, what additional lessons should come out of it.
Right. And it also seems like, while in some ways unique, in other ways, it seems very similar to the data subject rights that individuals have under various state laws, right? This is just a new form of those rights where individuals have the right to be able to terminate a particular subscription through a simple means as opposed to following a more convoluted, less clear process, which is going to result in them having to stay on that particular platform. And so I wonder, as this starts to develop outward, that there will be a larger focus on organizations as they're anticipating how to effectuate DSAR rights, data subject access rights, and other data subject rights, and this being one of perhaps others that are on the horizon as well.
I wouldn't be surprised at all. I think particularly with consumer protection and data protection in general, regulators are not just thinking about these in silos. And so they're going to try to think about, okay, if we are learning this lesson from one area, so these negative options in particular, what are the lessons that they can take out and apply to, every other area within their jurisdiction, which could include, consent, it could include data subject access rights, the entire gamut.
Interesting. So as I understand this particular rule, however, is that the FTC wasn't unanimous in its adoption of the rule. In fact, there was a pretty strong dissent. Where is the criticism of this rule? Where is that kind of others folks who are thinking about this differently? Where do the concerns lie?
So part of the focus is both procedural and then substantive. So in terms of procedural pieces, the FTC had gone through a previous advance notice of proposed rulemaking. And so one of the criticisms that came out from Commissioner Holyoke, who's the one who wrote a dissent, basically said, the topics that you covered in your advanced notice don't line up with what you're actually issuing now. And so because of that disconnect, the idea is that the FTC should have probably put out an additional ANPRM before this final rule. So that is, it on the procedural side. On the substantive side, one of the interesting things is the requirements under the rule are very high level. They're things like don't misrepresent any material fact that you make while marketing goods or services with a negative option feature, or clearly and conspicuously disclose material terms before you're actually going to have the person consent to the negative option feature itself. And so on one hand, there's this feeling, of these aren't specific enough, that you're just sort of saying, don't misrepresent, and you're just applying it in this context. And in doing that, you're now actually getting sort of advanced enforcement opportunities, even though you haven't actually provided more clarity in terms of what is prohibited. The other side of it too is that a lot of these prohibitions exist in other laws. So I had mentioned ROSCA is one. A lot of these pieces are already prohibited under ROSCA. And so there's this question of, well, now what are you trying to do by actually going and creating a second set, so that the same practice might be considered a ROSCA violation, a violation of this trade regulation, even though it's the same conduct and the regulations are very similar. So there are a few pieces there where essentially Commissioner Holyoke pretty strongly said, both procedurally and substantively, the agency is now focusing more on political wins without taking the steps it needs to both go through the right procedural steps and then also make sure that these rules aren't just creating duplicative frameworks, that are trying to make up for, other losses that the agency has experienced in other areas.
Yeah, so it sounds like that was a pretty strenuous kind of set of objections. And nonetheless, however, we are in a position where this is now going to become the law of the land. When does it take effect? And what are the ways that organizations should be thinking about the resources and efforts that are going to be needed between now and that effective date?
So the full rule will take effect within 180 days of publication. So there may still be some time until we actually see formal publication in the Federal Register, but generally speaking, it's about 6 months from now. There are some smaller aspects that go in effect in 60 days, but really the 6 month threshold is kind of what you should have top of mind. In terms of what the practical impact for businesses are, realistically, it is that if you have a negative option feature, the potential risk exposure that you have has sort of, the dial for that has turned up to 11, essentially, because now things that may not even be directly tied to your negative option feature, may come under scrutiny under this rule, which may not have been a consideration previously. One of the particular ones is, this requirement around don't misrepresent any material fact when you're marketing a good or service with a negative option feature. To think about the gym example, right? If I own a gym and I say in 30 days we'll make you as strong as Arnold Schwarzenegger, and I now have a negative option feature that is not tied to my claims, the FTC can basically say your gym subscription has a negative option feature. The fact that you told people they could be as strong as Arnold Schwarzenegger in 30 days is a material fact that influenced people's decision to sign up for your gym. And even though they're not connected to one another, we're going to say you violated this rule. And, it's not just limited to some marketing claims, even things like if you say that you're independent, if you say, your certain data privacy practices may also come into scope here. And so if you offer this negative option feature, you're more clearly in the scope of the FTC than you were before.
So does that mean, as organizations are thinking about how to respond, it sounds like one, they don't have very long to make any of these changes if we're talking about 6 months, give or take, depending on when it is that the rule is actually published. And then two, what is needed is really a fresh look at the user interface that is being used inside of an e-commerce platform, especially around how organizations are allowing for individuals to control their membership. And then if I'm hearing you correctly, it's broader than that because you need to start thinking about all of the various promises and disclosures and, frankly, advertisements that are being made on a particular platform.
That's exactly right, Scott. The one other piece that I'll add that I think might be a big shift for certain companies is that this rule isn't just limited to B2C applications. The FTC made very clear they expect this to also apply to B2B circumstances as well. And so that's going to be something to think about in that, negative options and enforcement under ROSCA, that was primarily focused on the consumer angle. So in the B2B context, it may have been less of a priority. But under this rule, even if you're only a B2B business, you can't ignore it and just think, okay, I can continue to do what I was doing previously.
So, Harsmar, I want to kind of focus in maybe on one aspect of this application to the B2B relationships, because it's not uncommon. In fact, maybe it's more common than not that contracts from a B2B basis have some sort of auto renewal function, right? Evergreen function, whereby the agreement is going to continuously, if not affirmatively terminated or canceled by a party, will continue on for another segment of time. And that can be, another year, it could be another month, it could be another 3 years. Does this new rule impact that commercial negotiation?
It does. So the idea is that if you have some sort of auto renew mechanism, and to be clear, that's either an auto renew, let's say you have a click to accept agreement and the auto renew is part of that, or if you're individually negotiating, like you mentioned, the evergreen terms that say that the contract will keep going forward, with payments to be made periodically until the customer cancels, both of those would fall under the scope of these negative options here. And so you'll need to think through, if a customer says, okay, I want to cancel, what does that process look like? And to be clear, the cancellation is specific to that negative option feature. So it's just the cancellation of, okay, well, I want to say I don't want to be charged on an auto renew basis. You can still maintain the relationship, but you may then need to say, well, okay, we'll need to do an amendment that extends the term of our agreement, or you'll need to affirmatively go and say, I want to go and get this next month. But that is sort of the idea of the click to cancel model.
So if I have an agreement with an auto renewal function and a customer, determines that we don't want to have this be renewed, they can certainly follow the contractual mechanism under which they can terminate the agreement. But in that context, what additional right do they have other than following whatever the contract says?
So under this rule, they need to have a simple mechanism to be able to cancel that auto renewal. And maybe it's to say that they want to, that may be coextensive with termination of the full agreement, to say if there is no auto renewal, then we're not going to actually go and move forward with these services. It may be saying, listen, you can cancel the auto renewal, but now you'll need to go and take additional steps for each subsequent term that you want tacked on here. But it does make, like, the bottom line is it makes the process more complicated than it was before. And this is one of the reasons why some commenters really wanted to push to have B2B scoped out. The idea that these are typically negotiated at arm's length. Business customers tend to be more sophisticated, and these agreements tend to be more complicated. But the FTC, in particular, their lens was towards small businesses that may not have the same level of sophistication. And so with that base in mind, the entire process has gone, a lot more complicated than it was before.
So it's not that auto renewal or evergreen provisions are somehow now unlawful in the same way maybe that the FTC tried to make non-competes unlawful. You can still have evergreen provisions, but it sounds like for those to be enforceable, you also need to have a mechanism by which that you can cancel in a simple manner that contract within whatever period of time the contract allowed you to terminate the agreement.
Yeah, generally that's right. I think the only clarification I would make is, you had mentioned you need to have this cancellation mechanism in order for the auto renew to be enforceable. The rule doesn't affect the relationship between private parties. It's more to say that if you don't have that mechanism in place, now the FTC as an external third party can come in and say, you know what, we're going to ding you because you didn't give this simple cancellation mechanism. It's not to say that the customer can now get out of the needing to pay or something like that because there was no simple mechanism.
Got it. Okay. So yeah, important point. In other words, it doesn't mean that the contract itself wouldn't become enforceable. It's just that the FTC may have some additional right to be able to bring some enforcement action against the company for implementing evergreen provisions in ways that didn't allow their customers to easily or simply terminate those relationships.
Exactly.
So why don't we just walk through an example of what that could look like, though? Because it's not yet clear to me how all of these things are connected. So let's just say you have a B2B relationship, and I'm a fan of the old sitcom The Office, and let's say The Office was a subscription to have 5 reams of paper delivered to you on a monthly basis, and Dunder Mifflin was implemented a negative option around the cancellation of that 5 reams of paper. What would Dunder Mifflin need to do, and what would it need to be concerned with when it's looking at its disclosures around that membership to now comply with, or perhaps maybe avoid the scrutiny that's available under this new rule?
So there are a few pieces. One is around, if signing up for the 5 reams of paper or the 5 boxes of paper a month is as easy as calling Jim and saying, hey, I want to do that. But if all of a sudden you realize, hey, I can get a better deal down the street, and you can't just give another call to Jim, you need to go through a long process, that's going to be something that the FTC could have in their sights because there's not a simple way to cancel. There are also other pieces around, similar to that Jim example. If you say, hey, our paper is super eco-friendly, and that inspires someone to sign up for a the sort of subscription, and ultimately it turns out that that was a misrepresentation, you could also fall under this rule, because that misrepresentation may have encouraged someone to actually sign up for your subscription, even if it's not tied to anything around how often they'll be charged or anything like that.
So, a company comes in and says, we have the best, Dunder Mifflin says they have the best paper in the history of papers, and that's what encourages people to sign up. And it turns out that they don't have the best paper in the history of papers. Isn't that kind of a more typical Section 5 deception type of position, or unfair, marketing type of position? How is that connected back to this new rule?
So essentially, the rule is saying if that misrepresentation is a misrepresentation related to a good or service with a negative option feature, right? Then it will fall under this rule specifically, which, to be clear, I think this is one piece that may be a little confusing for folks around how this rule relates to Section 5 generally. They're coextensive. So the practices that are described in this rule are pieces that would be considered Section 5 violations in general. The difference now, though, is that, with a general Section 5 violation, typically what the agency has done is they'll enter into a consent agreement, and if you violate that consent agreement, that's when monetary penalties may be implicated. If you violate a trade regulation rule, the FTC can go after penalties in the first instance. Mm-hmm. And so, that sort of broadens the scope of, you're right that this would be normal Section 5 authority, but now all of a sudden, if it relates to a good or service that has this negative option feature, the FTC can get penalties in the first instance, which may make them more likely to, even if the fact that you described isn't directly tied to that good or service with the negative option. If you say you have certain, let's say you say that you handle the data with those purchases pursuant to GDPR, and it turns out you actually don't. Those are things where the agency can say, if someone signed up for the subscription, this was a material fact that you presented to them, and because you misrepresented it, we're going after you under this rule specifically and going after penalties in the first instance rather than under Section 5 generally.
Got it. Okay. So in other words, it doesn't necessarily tie directly back into how you can cancel it. It just almost expands the authority under which the FTC can bring action for monetary penalties as opposed to engage in other type of resolutions. And so it's really, to the dissenting opinions point, designed to perhaps cover ground that already exists, but allow for a bigger, call it, sword for penalizing that type of behavior.
Exactly.
So, Hartsamar, this is super helpful. And, I think maybe where I would interested in your thoughts as we conclude here is, what does this type of rule mean for the folks who are in our profession, right? I mean, I will often say, and I've said at the start of the podcast, is that, our profession here is changing rapidly. And it's becoming, while privacy and cybersecurity is a key component of it, it extends outward from traditional privacy and data security principles, including to, expertise around how UI needs to work, and how is it that you are going to prevent allegations for dark patterns, or prevent issues surrounding these types of click to cancel rules or negative options. There seems so many different components that's baked in here, and as individuals who are responsible for steering their organizations from a data perspective, it seems like it really requires an additional skill set to be layered on top of that foundation in privacy, data protection, and consumer protection.
Yeah, I think regulators are trying to broaden their scope of all of the different subject matters in the law that they can pull together, and where they can take lessons from one area and apply them to another. And so, as data protection attorneys, one of the things that we have to do is to sort of keep an eye on the broader playing field, and to make sure that we're staying up to date on not just what is the direct data protection enforcement actions, but also the broader consumer protection angles that the regulators are bringing and the various ways that they are trying to tackle these problems. Because if they can't go at it through, maybe one avenue, they'll often try to figure out, is there a way to address this, the unwanted behavior that, in their eyes, from a different one. And so we have to sort of have this broader thinking around, okay, if it's not going to be just this one place, what are the different angles that this might be looked at from, and how exactly, can we best mitigate risk for the company or for our organization?
Yeah, really fascinating. I'm very interested to watch how this develops, including from how this is enforced and how more specificity is added around what constitutes simple means by which individuals can cancel subscriptions. And frankly, as you're just pointing out, this is an area that will continue to probably grow as regulators are looking at all different ways that technology is being used by consumers and consumed by consumers, and how that individuals may have more control and visibility around how that technology is designed to work, that may have impact on their lives.
Yeah, it's an exciting and very busy time, but always something new to learn about.
Well, with that, Harsmar, really appreciate your expertise and contributions to this episode in the podcast. I'm sure you'll be back many more times to help listeners understand what is happening on the policy side. So thank you for joining us.
Thanks so much for having me.
With that, I'm Scott Laughlin. This is the Data Chronicles, and those were your data points.